Jail custody since
Please adjust your mic.
appellant in jail custody since 14 years.
My lord, the appellant is in custody since 2015.
May I please, my lord? My lord, there is a criminal revision petition, your lordship. I'm concerned to make a mention, your lordship, because the Law and Additional District Judge has rejected the list of defense witnesses, your lordship. This trial is going on in a POXO case since last 4 years.
No, is it a division bench matter?
No, that's why I said I'm concerned, because the Law and Additional District Judge has put up the matter.
No, if it is why are you mentioning then? If it is not a division bench matter, why are you mentioning before this bench?
Because this urgency for you, it is your lordship's assignment. That's why I prayed that I'm concerned to make a mention, because the Law and Additional District Judge has put up the matter for 16 without any defense witnesses. That's why I was
tied up matter. Is it a
tied up matter to your lordship's court, single bench.
on which on this?
My lord, petitioner is in custody since 16 years. I have filed bail 3 times. I have filed this memo, but not had been listed.
Fresh criminal appeal.
My lord.
Fresh criminal appeal.
Yeah. There is submission. Voting ଅଛି ତ?
Weekly list fresh admission item number 7.
Life imprisonment.
So in the I'm interested for
No, sir is to see that list. There is a list prepared by the
legal.
High Court in a life imprisonment case who are to be engaged. So, sir will engage. So, admit, call for the trial court record. Lucky sir on the David. Second one also same, life imprisonment.
My lord, I am interested to know.
Okay. Verify the list if sir will see that. Next, admit call for the LCR. Yes. Next one also same.
Same matter. Up to 14.
Yeah. All are admit call for the trial court record. Plus all. Son proposal. There number ta kon achi? Delay life imprisonment.
Life ଅଛି. ସବୁବେଳେ life.
2007 still on. Since it's a jail criminal appeal, delay is condoned. Add admit. And life imprisonment sentence has been awarded. Delay is condoned. Admit. Same order in item number 3. Delay condoned. Admit.
Item 15. Item 16.
Well, on behalf of H.S. Mr. Mehra, the appellant is convicted under 302 and the fine amount is, my lord, 10,000.
Life imprisonment.
My lord.
Press matter.
Yes.
All right. Same order. Admit खाली आधेरे ଗୋଟେ application form issue to bail and stay relation to be considered after receipt of the trial. Yes.
17.
May I please your lordship? I am appearing on behalf of Mr. C.R. My lord, in this case, the case was listed suddenly and we don't have the required papers right now. So kindly list it for
The
some others.
paper book has been prepared.
Yes, my lord. But
So you are to receive the paper book and argue the matter.
yes, my lord.
So you receive the paper book.
Yes, my lord.
That's a connected appeal, my lords. Out of the same trial, both have been convicted, my lords. We are for the connected appeal. I pray,
Which
lordship,
is the connected appeal?
Connected koda. Connected koda.
There is only one criminal appeal, mister. It's
sir.
246 of
I'm
2009.
sorry, it is the next item.
The uh, how many appellants are there? Appeal member.
My lord, 6.
6. So Mr. C.R. Sahoo is appearing for all of them or
I don't have the instruction, my lord.
এটা তো করো বলো जो অযোধ্যা রঞ্জন দাস कितने नंबर आइटम 46 है
246. Sibomunda, appellant number 6.
नहीं এই জুটা ପାଇଁ ଯୋଉ ଫି ନାମାଟା ଟ୍ରାଏଲ ଫର ଜଜମେଣ୍ଟ ପରେ ଯୋଉଟା ଫି ନାମାଟା ଅଛି ତା ଦେହରେ ପ୍ରାୟ ସମସ୍ତଙ୍କ ପାଇଁ 5 6 ଜଣଙ୍କ ପାଇଁ ଅଯୋଧ୍ୟା ରଞ୍ଜନ ଦାସ S.K. ନନ୍ଦ ତାପରେ
Only for appellant number 6.
ହୁଁ ହୁଁ
Ajodhya Ranjan Das for rest of the appellants. 1, 2, 3, 4,
PK बेउरा और 916 का जो ना जो करत ना हो नहीं क्या PK बेउरा एक सोरंगी ना how do you know of it?
ଶିବମୁଣ୍ଡା ଠିକ ଅଛନ୍ତି
ଅନ୍ୟମାନଙ୍କ ପାଇଁ ପୁଣି କିଏ ରହିଲା ସେ ଅନ୍ୟମାନଙ୍କ ପାଇଁ ସେ ଯୋଉ वकालत नामରେ ଯୋଉମାନଙ୍କର ନାଁ ରହିଛି ସେମାନଙ୍କର ନାଁ କଜ୍ ଲିଷ୍ଟରେ ଆସିନି ନା ଦିଟା वकालतनामा ଅଛି ଏଇ ଦେଖ ଦିଟା वकालतनामा ଅଛି ତ ଏମାନଙ୍କ ନାଁ କେମିତି ଆସିଲା PK ବେଉରା AK ଷଡ଼ଙ୍ଗୀ ତାଙ୍କୁ ହାଇକୋର୍ଟ ତରଫରୁ ଏନଗେଜ କରାଯାଇଛି କୌଣସି 2009 ମସିହା name of AR Das be deleted ହେଇଯାଇଛି order dated 5/3/2024 ତାପରେ କେମିତି ଆସିଲା अच्छा ହେଲା ଠିକ ଅଛି CR ସାହୁଙ୍କ ଆସୋସିଏଟ ହେଲା ଜଷ୍ଟ ହେଲା CR ଦାସ ଦେନ୍ PK ବେଉରା AK ଷଡ଼ଙ୍ଗୀ ବାକି ରହିଲେ ଆଚ୍ଛା SK ନନ୍ଦ IR ଦାସଙ୍କ ଜୁନିୟର ପୁରା ଅଲଗା ଅଲଗା ହେଇ ରହିଛି ନାଇଁ ଠିକ ଅଛି P ମହାପାତ୍ର ଆଣ୍ଡ SN ସାହୁ ଆସି ଆପଣଙ୍କ ନମ୍ବର 6 ତ ଏମାନଙ୍କ ପାଇଁ
ମିଷ୍ଟର ସୁବେନ୍ଦୁ ସର ବି ଅର୍ଡର ସିଟ୍ ବାହାରିଛି ଅଛି
ଯୋଉ ଫାଷ୍ଟ ପେଜ ଟାକୁ ପଳେଇ ଆସିଲେ
ଅର୍ଡର ସିଟ୍ ଅଛି ତ
ଏଇ ଯୋଉ ପେଜ ଟା
ଆମେ ସେଟା ଦେଖିଛି 20 ଫେବୃଆରୀ ଗୋଟେ ଅର୍ଡର ଅଛି ମିଷ୍ଟର ସୁବେନ୍ଦୁ କର ବୋଲି appearing for the appellants all the appellants
associate with
people simply concerned take instruction. Let them take instruction. It's not an specific because she has no instructions.
Color number phone number
Appellant number 6.
ଦି ଜଣ ବେଲ୍ ହେଇଯାଇଛି 22/4/2014 4 ଆଉ 6 ଯୋଉ 6 ପାଇଁ ସେ ଆପିୟର କରୁଛନ୍ତି 2 ନମ୍ବରର ପ୍ଲେଟ୍ ରିଜେକ୍ଟ ହେଇଛି पूर्व 3 या 5 को bail है, so except number 2, everybody is on bail. One, 3, 5 released on bail on 25/2011. Then 4 and 6 released on bail on 22/4/2014. Only 2 has been rejected. पूरा bail है. Mr. Das, there are 6 appellants in this criminal appeal. Mr. C.R. Sahu is appearing for only one appellant, that is appellant number 6. 6, right? Yes. And that appellant number 6 is Sibo Munda, who has already been released on bail by this court on 22/4/2014. And similarly, 1, 3, 5, 4 have also been released on bail. So only number 2 is in custody. So we will do one thing so far as number 2 is concerned. We'll ask, since the counsel is not appearing, we'll ask the land and trial court to obtain instruction, or we can connect him. So far as the other appellants are concerned, this IIC of the concerned police station should bring all of them to the nearby court, that is, it would be Champua. So that we'll ask them whether they are to engage any counsel on their own, or any counsel will be, because it's 2009 matter. He cannot argue the matter for the other appellants. They have already engaged. So we are fixing a date next week. Maybe on Monday we'll do this exercise. Your IIC should bring them to the concerned virtual mode at Champua, so that we'll ask him.
Will appear through virtual board.
Right. We'll ask directly if they want to engage any counsel. It's all right. They may also contact their earlier engaged counsel, because if the counsel is not appearing. Right. And simultaneously, you do one thing. Why don't you also obtain instruction through concerned jail superintendent about the appellant number 2? If he wants to engage, otherwise we will engage another. Okay. Yeah. Look. A mention is made, that is item number 17, on behalf of C.R. Sahoo advocate for adjournment. C.R. Sahoo advocate, who is appearing for appellant number 6, Sibo Munda, for adjournment. On perusal of the order sheets, it appears that this court has granted bail to appellant number 1, 3, and 5 on 25/2011. And while granting bail to appellant number 4 and 6 on 22/4/2014, the bail application of appellant number 2, Chaitanya Munda, was rejected. Chaitan Munda, been rejected. Since none appears for appellant number 1 to 5. Let the London State Council obtain instruction from appellant number 1, 3, 5, 4 and 5 who are on bail through the inspector in charge of Joda police station, whether they want to engage any other counsel to pursue this appeal. Similarly, instruction be also obtained from the appellant number 2, who is now lodged in subjail Champua, if he wants to engage any other counsel. It should be apprised to all the appellants, that is appellant number 1, 2, 3, 4 and 5, that if they have no financial capacity to engage any counsel on their own, counsel from the High Court Legal Aid panel shall be engaged for them. So we are keeping this matter on 20th of May of 2024, because this it will be handed over to you. You are just to
17th.
17th you are. All right. Better. 17th. 17th May 2024. Free copy of the order.
So placed, my lord.
Item 18.
May it please your lords. The prisoner, a lifer, has been in custody for about 12 years. Twice was granted interim bail and
How many appellants are there in?
2 appellants are there. I am for only one.
You are for appellant number?
Last appellant. Last appellant. For the second appellant, my lords, there's a prisoner petition praying engagement of my
No,
lord.
it's all right. We are now holding this brief CRLA number 391 of 2014.
My lord.
There is only one appellant,
One appellant.
right?
My lord.
So
He
you
has
have applied for bail.
Twice
that
he was granted interim bail and surrendered in time.
Okay.
And in custody for about 12 years.
No, how many times you have been granted?
Twice.
On which date?
I have given 18, 11, 22 once.
18, 11,
22.
and
then 11, 10, 23.
11, 10,
23.
23. First date 18, 11, 2022 for how many months?
2 months, 8 weeks. 8 weeks.
8 weeks. And this
thereafter also 2 months.
11, 10, 23.
He has surrendered in time and on
Just a minute. That was for 2 months. Okay.
My lord. Surrender certificate also have submitted last month.
So 2014. Yes, Mr. Misra. So initially you were taken into custody for on what date?
Date, my lord, I have submitted.
Your sorry, that paper book have a trial court record. Trial court.
Date of custody.
Final form where so when final form was submitted as a court surrender court surrender. And during trial you are not granted bail.
No. I was on bail. He was on bail. Initially he remained in custody for about 2 years.
Hmm.
And thereafter he was granted bail, and on the date of judgment he was taken into custody. 14
When date of judgment?
Malad.
अच्छा 23/7/2014.
Malad. Since then he has been in custody, except that twice he was granted interim bail.
So Mr. Misra, say division bench decision of this court says that initially you are to be granted bail for 3 months, and if the conduct is okay and there is no likelihood of the appeal being taken up, then that is to be made final till date. So he has been granted bail twice and surrender at right time. Surrender certificate has been filed. So you are not bringing anything on record that he has misutilized his liberty during the period of interim bail. So what is your submission? He's remain in custody for what is the
About 12 years.
12 years.
Yes.
What do you say?
Well, my submission is case solution 302, and there are eyewitnesses who have said against the present petitioner. The deposition and testimonies are also there against the present petitioner. So my submission is that why she was granted interim bail, my lord, 302 case. Why interim bail, my lord? Let the paperwork is ready, so hearing may be completed, my lord.
How can the hearing be completed?
Paperwork is ready, my lord.
So many cases, paper books are ready. Are we able to take up all those matters finally? It's a single death.
My lord, single death. My lord.
And what about the eyewitness account?
Eyewitness PW 1 and 11.
PW 1
stated
and 14, my lord.
14. Yes.
You want to place 14?
My lord. Yes, sir. नोट तो सबमिशन दिया ही दे दो सारा तो दे दो In fact, both were chance witnesses, man. They were saying that they were coming from their shop, and on the way they saw the affair. But this PW, so far as PW 14 is concerned, your lordship may kindly.
Okay, you do one thing, Mr. Since it's a Cuttack case, and is that Lord's Hotel case?
My lord, yes, sir.
Oh, I see. Then you do one thing, you take instruction whether during this period of interim bail,
Yes, sir.
Is there any allegation of misutilization of liberty? Number one. Number two, whether any criminal antecedent is there against this petition.
Yes, sir.
That will be. Mr. Basudev Pujari, Land Counsel, appearing for the appellant, submitted that during trial, the petitioner was on bail after remaining in judicial.
No, during trial he was not on. Sorry, I'm sorry. I'm sorry. I thought it was.
After remaining in judicial custody for 2 years.
My lord.
And after pronouncement of judgment on 23/4/2014, he was taken into judicial custody again, and he has been granted interim bail twice by this court.
My lord.
Once as per order dated 18/11/2022 for a period of 8 weeks, and the second time on 11 as per order dated 11/10/2023 for a period of 2 months. And after availing the interim bail period, he surrendered at right time. let the Learned Counsel for the state obtain instruction as to whether there is any allegation of misutilization of liberty by the petitioner, appellant, during the period of interim bail granted by this court, and if there is any criminal antecedent against the appellant. So, put up this matter on 20th of May 2024. Which police station, Mr.
Courier PS.
Purikar? You get that? Free copy of the order behind it.
And there is one, my lord, on 18/1/2022 year, my 2020.
22.
The date, my two dates, my lord.
18 আমি অর্ডার কপি দিয়ে দেবো প্রথমটা হচ্ছে 18/11/2022 রে
Yes.
8 weeks ପାଇଁ ଯାଇଥିଲେ
ଆଜ୍ଞା।
ସେକେଣ୍ଡ ଟାଇମ 11/10/2023 ରେ 2 ମାସ ପାଇଁ ଯାଇଥିଲେ
ଆଜ୍ଞା।
ଠିକ
8 weeks, 2 months. 8 weeks.
yes sir, what is the connected matter you said?
Connected matter, my lord, out of the same trial, another accused appellant. In the meantime, a prisoner petition has been received to engage my learned senior Mr. Das. We have filed the wakalat thereafter, my lords.
Where is the vinama?
Lords, wakalat has been reflected in the court
Prisoner's
list.
petition so also for engagement it's all right, but you have to file vinama also.
The fresh wakalat names have been
Acha acha हाँ अच्छी Kishore Kumar Saw, I saw all right there.
identical, my lords. He was also released on interim bail several times.
Same date, right?
No, my lord, not on same dates. He has been released 3 to 4 times on 4 occasions, my lords.
Okay. No. First, tell us that whether during trial you are on bail or not.
During trial, he was on bail.
And this court has granted bail you on some
Interim bail. Interim bail.
ये जो interim bail ये accused ର କେତେ ଥର ଯାଇଛି ସେ orders ଦେଖିଦେବେ order sheet ରେ ଜଣା ପଡିଯିବ ହେଲା ସେଇ type ର order କରି instruction ମଗେଇଦେବେ misutilization liberty criminal antecedent ହେଲା ତା ଉପରେ ଲେଖି ଦିଅନ୍ତୁ period the prisoner's petition of the appellant at flag J praying for engagement of Mr. Devasnan Das as his advocate. Mr. Das has filed vinama. The same is accepted. The names of other counsel except the name of Mr. Devasnan Das and his associate shall not be reflected in the cause list. Submit that he was on bail during trial, then after being convicted he was granted bail on such and such date. And so same date, it is to come along with 391 of 2024 on 20th of May.
Item 19.
Wait, please, Your Lordship. Your Lordship, the present petitioner has been in custody since 4/4/2010, Your Lordship.
Your earlier bail application was rejected by this court.
Your Lordship, twice I have been released on interim bail.
Interim bail.
Yes, Your Lordship. The
So-
first is on dated 15.
Just CRLA 7 of 2014. So during trial you were on bail or
Your Lordship, I was not on bail duty.
not on bail? So during pendency of this appeal, how many times you have been granted interim?
Twice I have been
Twice.
granted.
Can you tell what are the order dated?
Yes, Your Lordship.
Yes.
The first is order dated 15/11/2017.
15/11/2017 for how many?
4 weeks, Your Lordship.
4 weeks.
Yes, Your Lordship. I have surrendered on 19/12/2017.
Then second time?
Second time is 10/11/2020 for a period of 21 days.
And you have been convicted under section
302, Your Lordship.
life imprisonment.
Yes, Your Lordship.
Direct evidence.
Yes, Your Lordship. There are eyewitnesses to the occurrence.
So, what is the name of the deceased?
Name of the deceased is Arthur Swain, Your Lordship.
Artho Swain.
Yes, Your Lordship.
Date of occurrence?
3/4/2010, Your Lordship.
Who are the eyewitnesses to the occurrence?
Eyewitnesses are PW 7,
Hmm.
8,
Yes.
11,
Hmm.
12, 15, and 17.
Just come to one eyewitness PW7 को पढ़े सुन कौन को
Position copy is not filed, my lord. The position copy is not filed.
Your Lordship, earlier we had 5.
पेपर बुक ही नहीं थी ना so then you are to give it the paper let us see that what is that APW7 कितने page है you are having those copies with you
Yes, Your Lordship. I have the copies.
so you supply it let him go through it so you
Your
can
Lordship.
pick up this matter day after tomorrow from this weekly list
Yes.
supply at least this deposition copies of these eyewitnesses and
All the
doctor
witnesses.
PM doctor
Yes, Your Lordship.
okay
Yes, Your Lordship.
Mr. Mishra,
My lord.
we are taking up this matter on 15th
Yes, ma'am.
from this weekly list. And during course of the days, we will provide you the deposition copy of all the eyewitnesses, 6 eyewitnesses,
Yes, sir.
so also the doctor.
Yes.
Item 20.
Item 20, I may be permitted through VC, my lords. Lordship, kindly see the last order, my lords. By the last order, considering that the appellant has remained in custody for 9 years and 7 months, some odd, my lords. Lordship was pleased to call for the custody certificate, and the State Council was directed to obtain the custody certificate of the appellant, my lords. The last occasion, I also filed a death chart, my lords, and also served.
Just a minute. Custody certificate, then criminal antecedent. These were the things we required, and any kind of problem, if there would be any.
Instruction has come.
What is your instruction? Pass on. ଆଉ 302 କେସ୍ ଅଛି କି?
Yes, same that you mentioned.
Same to ଏଇଟା କଣ? So, what is this case? Life imprisonment?
My lords, 302 is the charge, my lords, life imprisonment, and his date of custody, my lords, is 2010-2014, my lords.
Just a minute.
2010-2014.
Twenty-four 2015.
2010, my lords, 2010.
2010 ତ?
ଆଜ୍ଞା
2010-2015
14
14 ଆଚ୍ଛା
ଆଜ୍ଞା
2010-2014 and you have been found guilty under section 302
my lords.
acha life imprisonment. So what is the name of the deceased?
Deceased, my lords, is Shiva Singh, my lords. I have filed a death chart, lords. You kindly see. The last occasion I had provided 2 copies for the.
Okay. Registered 302 charges, some charge framed conviction 302. All right, date of occurrence 39 Date of FIR 49. So second page you have mentioned
My lords.
that PW1 torn hostile, 2 torn hostile, 3 torn hostile,
Yes, yes, that is
4,
the position.
5, 6 hostile, 7
Yes.
is the doctor PM, then 8 is the doctor who recorded dying declaration, nurse was there,
Yes.
pharmacist was there. So mainly dying declaration, your conviction has been based.
My lord, that is the sole basis, my
So
lord.
let us come to that doctor. That is
10, madam.
Memo. Doctor Uchi PW8 na.
8, PW8. PW8.
What's that card?
PW8 is the witness who supposedly.
PW8. Okay. Being asked by me, the patient told on that day, that is on 3/9/2014 at about 7 p.m., when he asked his son Maheshwar Singh to work in the cultivable land and to feed their cattle, he quarreled with him and told him to work in the land. The patient further told that an altercation took place between him and his son, and during altercation, his son Maheshwar got angry and assaulted him on his belly, so and so by means of an axe. Okay, so it's a case of patricide. So son has killed the father.
My
And
lord.
what are the injuries sustained? PM doctor is
Postmortem Dr. Millards.
PW7.
Yes, my lords. PW7.
Chop wound neck, chop wound left shoulder, upper chest, upper leg, mid abdomen. Oh, so many blows have been given. Your bail application was earlier rejected on
Yes,
May
yes,
3rd.
yes, Millers. That was some 8 years ago, Millers. That was rejected on 28/6/2016, Millers.
Keve?
28/6/2016. And after 8 years, Millers, this present application is moved to Millers. And PW8 Millers, in paragraph 6 of his cross-examination, he states, he admits that there was no certificate to the effect that the deceased was in a fit state to give his dying declaration. That is the admitted stand by the PW8 who allegedly recorded the dying declaration. And he further says that he cannot say in whose handwriting the alleged dying declaration was recorded, Millers. That is there, Millers. In addition to that, Millers, in page 23, page 3, Millers, that dead chart serial number 23, I have taken certain grounds. Lordship will kind enough to have a glance, Millers. And the PW 9 and 10, they are the medical officer, Millers.
Or the London Council. We are granting him interim bail because of the detention period for
Yes.
3 months. Okay. Or the London Council for the petitioner and counsel for the state. The London Council for the petitioner submitted that the petitioner was taken into judicial custody on 20/10/2014, and as such is in judicial custody for more than 9 years and 6 months. His earlier bail application was rejected on merit on 28/6/2016, and since there is no chance of early hearing of the appeal in the near future, as paper book has not been prepared. The bail application of the petitioner may be favorably considered. Learned counsel for the state opposed the prayer for bail and placed the evidence of the doctor who recorded dying declaration, that is PW 8, na?
Rule 7.
PW8, dying declaration by PW8.
PW8. So also the doctor bracketed PW7 who conducted post-mortem examination and noticed a number of chop wounds on different parts of the body of the deceased, who is none else than the father of the petitioner, and opined that the cause of death was due to shock and hemorrhage resulting out of the injuries to the vital organs like brain. In the case of so and so, say you leti versus considered and 3 months bail granted.
Replevelized man.
Item 21.
Yes, Mr. Mahaman.
May I please, Your Lordship? The petitioner along with another, they were convicted on section 302, section 34 of the Indian Penal Code, my lord. The deceased in this case is the wife of the...
What is this application for extension of interim bail?
No, he become infructuous.
Acha, let me. IA number 432 of 2024. This is an application for extension of interim bail. Mr. Mahapatra, Land Senior Advocate, submits that this interim application has become infructuous as the petitioner has surrendered after availing the interim bail period. In view of such submission, IA disposed of as infructuous. Yes. Now you are facing this IA number 611 of 24.
My lord.
Yes.
The petitioner was taken into custody on 20th 8 2013, my lord.
20th
2013.
8/2013. And during trial, you were on bail?
No. He was in custody.
During trial, not on bail. When the judgment was pronounced?
He was judgment
date of judgment.
8/2/2016. 8/2/2016.
Date of judgment.
8/2/2016.
8/2/2016. Thereafter, during this pendency of the appeal, how many times you have been released? Once. By order dated?
By order dated
24/11/2023.
24/11/2020. Interim bail for how many months?
3 months, my lord.
Okay.
And in time, he surrendered.
Surrender in time, sir. So, if you calculate the total period, what would be the total?
More than 10 years.
More than 10.
Just I will add one thing. The entire conviction is based on the dying declaration recorded by executive magistrate. 2 dying declarations were recorded. One was the IO that was disbelieved by the law and trial court.
DD recorded by IO.
My lord.
Is PW?
PW can declare IO. Just 1 minute. That was discussed, my lord.
No, you just want to know that 14 number टा होची से मंगलाबाग रो जोटा आईओ मेन आईओ टा केते नंबर अपन कहले ना आईओ रेकॉर्डिंग करतला बोली
সেটা হচ্ছে মার্ক হচ্ছে এক্সিবিট 5.
No, whether it was recorded by the IO or that Mangalabag.
No, IO, main IO.
Acha.
mark as exhibit 5 तीटा document होची exhibit 13 ଆଉ
exhibit 5 टा disbelieve ହେଇଗଲା
ଆଜ୍ଞା PW 14 my lord
PW 14
ନାଇଁ
just let us see PW 14 during inquiry and inquest Rescott party so and so no. Then the IAC endorsement I am acquainted with him. No, he is not the IO, main IO. He is the just
ऐसे enquiry को sorry
inquiry करছি से inquest करतीन तापर है
You PW 7 not sir.
7
Yes.
let us see that
7
PW 7 right. So that part has been disbelieved.
my lord
Then on whose dying declaration which was recorded by whom? Which was accepted and conviction was
PW 10 में
recorded by PW 10 से किए
executive magistrate.
अच्छा executive magistrate.
Executive magistrate.
executive magistrate my lord
What is the that dying declaration has been marked as exhibit?
exhibit
12.
Hmm.
So let us straight come to that exhibit 12 exhibit bar উপরে আসুন
এটা হচ্ছে exhibit 13 my lord the dying declaration
12 ଲେଖା ହେଇଛି ଦେଖିଦବା এটা 14 ଆସିଗଲା 12 କଣ ହବ এটা 10 ହଁ ଏଇଟା exhibit that is acha marked as exhibit 13 not bar 13 ର ତୁମର ନାମ ଠିକଣା କଣ ମୋର ନାମ ଅନିତା ନାୟକ ସ୍ୱାମୀ ସୁଆଂଶୁ ତମର ଘଟଣା କେବେ ଓ କିପରି ହେଲା ମୋର ବାହାଘର 9 ବର୍ଷ ହେଲାଣି ମୋର ବାହାଘର ପରଠାରୁ ମୋର ସ୍ୱାମୀ ମାମୁଁ ମଳାସୁର ମତେ ମାନସିକ ଓ ଶାରୀରିକ ନିର୍ଯାତନା ଦେଇ ଆସୁଥିଲେ ଆଜି ସକାଳ 19/8 ସୁଆଂଶୁ ସକାଳ ବେଳା 8ଟା ବେଳେ ମୋର ସ୍ୱାମୀ ଶାଶୁ ମଳାସୁର ମୋ ସହ ଝଗଡ଼ା କଲେ ମୋର ଶାଶୁ ଚିହ୍ନିବା ପ୍ରକାରେ ନା କହିବା ପ୍ରକାରେ ମୋ ସ୍ୱାମୀ ମୋତେ କିରୋସିନ ପକାଇ ନିଆଁ ଲଗାଇ ଦେଲେ ମୋ ସ୍ୱାମୀ ଜନ୍ମେଜୟ ନାୟକ husband so okay the husband of the deceased ନିଆଁ ଲଗେଇଦେଲେ ମୋ ସ୍ୱାମୀ ଶାଶୁ ସୁଆଂଶୁ ମୋତେ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ଏହା କରିଅଛନ୍ତି ମଳାସୁର yes so what is your submission
it was reflected in page 12 of the trial court judgment my lord what's last
page 12
my lord it was elicited from the mouth of PW 10 that he has not given any specific endorsement in the diagram to that effect that the doctor had given certificate just prior to her recording of the dying declaration. First of all, the dying declaration was recorded and on the foot, a certificate was given. Before recording the dying declaration, no certificate was obtained. He has admitted.
Who has given that certificate?
Doctor has given certificate.
That doctor has been examined.
Yes, PW 9.
9.
PW 9. In para 1 itself.
If your lordship will go through that document itself, certificate on the bottom. After recording the dying declaration, certificate was obtained. That is the crux of the matter. Whether the certificate was obtained prior to recording the dying declaration showing that she was in a fit state of mind to give such a statement. That's why I placed that part of it. And another aspect, my lord, your lordship may take consideration. There is the accusation against also the mother-in-law of the deceased. He has instigated. and she has been released on bail by this honorable court.
Hmm.
Keeping all these facts, I have urged upon this honorable court that when the incident took place, the parents of the deceased,
Hmm.
they were examined. They did not support that there was any animosity or any torture, because the charge was on section 304B, also CORAM 306, 498. All these offences were disbelieved
Hmm.
because they did not support, and there is no motive why the husband will kill the wife.
After how many years of marriage?
9 years,
9 years of marriage.
my lord.
Any issue out of wedlock?
Yes, two issues. The son was by then a small kid. Now he is prosecuting his study in the custody of the grandparents, and there is none else to look after the career. She is now, he is on 10th class. I have also filed the document. Extension file file document.
IA that is mentioned.
No, extension.
Extension.
To one son.
One son, one daughter.
One son, one.
And their career is at stake.
Heard Mr. Sorochandra Mahapatra and senior advocate. We are granting him interim bail again, and you are to produce a report. Then we'll apply that leti case. Okay.
Yes.
Heard Mr. Sorochandra Mahapatra and senior advocate for the appellant and counsel for the state. Mr. Mahapatra submitted that the petitioner was taken into judicial custody on 28 2013, and during trial he was not granted bail. After pronouncement of the judgment on 8 2016, he was again taken into judicial custody, and this court by order dated 24/11/2020 granted him interim bail for a period of 3 months, and after availing the same, he surrendered at right time, and he has never misutilized the liberty, and the petitioner has remained in custody for more than 10 years. It is further submitted that though paper book has been prepared, but there is no chance of early hearing of the appeal, and the petitioner was the husband of the deceased, and their marriage was solemnized 9 years prior to the date of occurrence, and they were blessed with a son and a daughter. The son is prosecuting his studies in class 10. It is further submitted that the conviction is based on mainly on the dying declaration, which was recorded by the Executive Magistrate PW 10, and the other dying declaration, which has been recorded by the IO bracket PW 7, has been disbelieved by the London Trial Court. Further submits that there are good chances of success and balance of convenience is in favor of the petitioner, and therefore the bail application may be favorably considered. And counsel for the state oppose the prayer for bail. Considering the submission made by the London counsel for the respective parties, and the period of detention of the petitioner in judicial custody, and since once this court has granted him interim bail for a period of 3 months, and he surrendered at right time, as submitted by Mr. Mahapatra, keeping in view the ratio laid down by the Honorable this court, division bench of this court in case and so on so, court kar devo, we are inclined to release him interim bail for a period of 3 months. During interim bail period, the shall not indulge in any criminal activities. IIC so shall give a report about the so. All right. And the another application is there for stay realization of fine. It is allowed stay realization of fine. Free copy of the order be handed over.
Item 22.
Yes,
Please, Your Lordship.
yes.
Mala I number 2106 by 2023 filed by the recall petition. So Mala allowed to recall petition. Honorable Judges D. Das and S.K.Pattanaik. Court has the law.
What order you want to recall?
Page number 2. This matter was listed
One
17
appears for the appellant and the matter is called yesterday matter was on accepting the payer fund. So we directed the matter to be listed from in the land. In the appeal is on the court is appending on Michael Security. Read a copy of some name of some. So why this order would be recalled?
बार बार लिस्ट ହେଲା ସେଦିନ ଆମେ ରହିପାରିଲୁନି କୌଣସି ଗୋଟେ ମିସ୍ତ୍ରୀ ଯୋଗୁ ସେଥିପାଇଁ ଆମେ ସ୍କିଓର ଭାବରେ ଆପଏଣ୍ଟମେଣ୍ଟ କରିଦେଲେ ଅନରେବଲ କୋର୍ଟ
Yes.
ସୋ ମାଇଲର ଆମେ
What else this court would have done? 2016 criminal appeal, when the matter was called for hearing, the counsel for the appellant was not present, and taking into account that it is an appeal of the year 2016, this court appointed amicus curiae to assist the court. Now the counsel is there. You are the counsel. So you assist him. There is no problem in assisting. He must have been.
I have collected.
You have received the paperwork.
Yes, ma'am.
So he has prepared in this case. What would happen if we assign to you, and what would be the taro jo parishrama se karichhanti ya bhitere after taking the paperwork as per the order dated 18/8/2023. So you assist him and let him argue the matter.
Okay, madam.
Okay. So amicus curiae will continue. You also we can hear you. There is no problem. He will be paid his own fees. So this partial modification. IN number so and so is an application for recall of the order dated 18/8/2023. It appears that when the matter was taken up on 18/8/2023, the Land Counsel for the appellant was absent. Taking into account that the appeal is of the year 2016, this court appointed Mr. Prabhav Behera as amicus curiae to assist the court in hearing and disposal of this appeal. Mr. Prabhav Behera, Land Counsel, is present and he submits that as per the said order dated 18/8/2023, he has received the paper book and is also prepared to argue the matter. This interim application has been filed by the counsel was earlier engaged by the appellant on the ground that inadvertently they missed the list and they could not remain present on to recall the order dated 18/8/2023 on the ground that on the date fixed did not remain present, uh, and they may be given the opportunity to argue the matter. After hearing the learned counsel for both the parties, we think it proper that instead of recalling the order dated 18/8/2023, both Mr. Prabhav Behra and amicus curiae, so also Mr. Jyotirmoy Sahu, the learned counsel engaged by the appellant, will be given opportunity to address this court on merit of the criminal appeal. So this is ready for hearing. So both of you get ready. We can take up this
Lordship, I
matter.
have fixed a date as per my Lordship's convenience.
The matter be added to the hearing list be commencing from 24th June 2024. With the partial modification of the order dated one, so this IA is disposed of. MC number 595 of 2016 is an application for stay of realization of fine. That is state fine state.
Present.
Yes, next.
Item 23.
May it please your lordship. My lord, the appellant number 1 is in jail custody since 30th of January 2014 for more than 10 years on the allegation.
You have filed the bail application only for appellant number 1.
Appellant number 2 is already granted bail.
Okay, no, total appellants are 2.
Son and mother.
Okay, you have not filed for appellant number 1. This is Santosh Kumar Ponda,
my lord. Husband of the deceased.
Husband of the deceased.
The deceased is Urmila Ponda.
Urmila. And what is the conviction and what is the sentence?
302 conviction by 304B. And the sentence is life imprisonment.
302, 304B.
My lord.
Life imprisonment.
My lord. I am in custody since 30th of January 2014.
30th of January 2014.
Marriage took place on...
during trial, you were not on bail.
No, my lord. Throughout, I am in jail.
After the appeal was preferred, this is an appeal of the year 2016.
My lord.
You have never been granted interim bail.
No, my lord.
Okay.
I have filed a bail application earlier, that is 8 years before. It was rejected by order dated 22/7/2016.
22/7/2016. Earlier bail rejected. Okay.
The date of marriage is 23 January 2013.
23
January 2013. And the date of death is 26th January 2014. There is no issue out of the wedlock.
And what is the cause of death?
That is hanging. The learned trial court was of the view that it is homicidal. But your lordship, my contention that it is practically suicidal. Because of the...
What is the PM report or the doctor who conducted PM?
Doctor who conducted opined that the thyroid cartilage is intact. And
who is the doctor?
PW7, my lord.
PW7,
my lord. Your lordship, may kindly...
Just a minute. The doctor has opined it is asphyxia due to strangulation.
My lord, the doctor has opined, but your lordship may kindly see the doctor's evidence.
You see, the first reasoning he has given, number 2, that this ligature mark was horizontally placed and encircling the neck. It was not in oblique manner. So that was the main sign. In a case of suicide, it would have been a oblique in nature.
My lord, but it is not completely encircled. My lord, thereafter the
completely encircled ଏଇଥିପାଇଁ ନୁହେଁ ଯଦି ବାଳଟା ଚୁଟିଟା ଯଦି ରହିଯିବ ପଛରେ ଭିଡ଼ିଲା ବେଳକୁ ସେ ଚୁଟିଟା obstruction କରିବ ତେଣୁ
the cross examination she has stated that it is above the thyroid cartilage and it is up to the back hairline. So your lordship,
all right, on merit,
no,
your
not on
bail
merit.
application was earlier rejected or not?
On 22/7, not on merit, my lord.
Now on about the detention period is
10 years, more than 10 years.
10 years.
My lord, not on merit, but the fact that the father died, the mother, that is reflected in the earlier order, that the 13/9/2017.
Whose father died?
My father died. That is already in 13/9/2017, while granting bail to the mother, my lord.
Okay.
The lordship has been pleased to consider it also while granting bail to the appellant number 2. Now,
It's all
nobody.
right. That it's not that you are to go and perform the obsequies.
No, not that, but mother is there. Nobody else.
Nobody else is in the family. That you say.
And more than 10 years I am in custody.
Are the learned counsel for the petitioner and counsel for the state? The learned counsel for the petitioner submits that the petitioner Santosh Kumar Panda with the appellant number 1 is the husband of the deceased Urmila Panda, and he was taken into judicial custody on 30/1/2024. He was not granted bail during trial, and his earlier bail application was rejected by this court on 22/7/2016. And as such, he has remained in judicial custody for more than 10 years. Learned counsel further submits that even though the paperwork has been prepared, there is no chance of early hearing of the appeal. He submitted that though the doctor who conducted post-mortem examination has been examined as PW7 and opined the cause of death to be asphyxia due to strangulation, but the surrounding circumstances and materials available on record indicate that it may be a case of suicide, and there are good chances of success in the case. Balance of convenience is in his favor. Therefore, the bail application may be favorably considered. Land counsel for the state, on the other hand, opposed the prayer for bail and submitted that the marriage was solemnized on 23/1/2013 and the deceased died on 26/4/2014 and
26/1
2014 तो
26/1
तो
आगे
26/1/2014, and the doctor's evidence clearly indicates that the death is homicidal one. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced during trial, and keeping in view the ratio laid down by this court in so and so, not inclining so and so, we are granting him interim bail for 3 months. And this report we called for from the IAC, okay, about his conduct during the period of interim. Yes, and sterilization of fine. Obliged to lodge.
Item number 24.
May I please announce it? Alert,
Yes.
yes, alert. May I please announce it? Alert, custody since 10 years, 7 months, my lord. It's appellant convicted under section 302, 307 And 201 of IPC, my lord.
Just a minute, 124 CRLA 635 2016. Sole appellant.
My lord.
Arthro alias Arthro Hon'Ble. So 302
My lord.
life
302
imprisonment.
life imprisonment.
And you are in custody since
Custody since my lord 17/10/2013, 17 October 2013.
not released during trial.
Never released, neither interim bail nor.
So what is the name of the deceased?
Deceased my lord Basudev Mohanto.
Basudev Mallo
Mohanto.
Mohanto. Date of occurrence?
Date of occurrence my lord 16 October 2013.
Eyewitnesses are there.
My lord.
Who are they?
PW 5, 6, 7, 8.
PW 5, PW 6,
7
PW
and 8.
7 and 8.
8.
Okay. And who is the doctor?
The PW 20 my lord.
PM doctor. PW 21.
20.
So you come to PW 5 evidence.
Position copy is not available in the.
Copy deleni?
I'm the present counsel, earlier counselor, not.
Okay, just see that. ପଢନ୍ତୁ ଆପଣ ପାର ଅଛି ଟି?
My lord.
ହଁ ତାଙ୍କ ପାଖାପାଖି ରଖିକି ପଢନ୍ତୁ. Please come to paragraph number 2, where the assault part has been stated.
PW 5 my lord.
PW 5, yes.
Paragraph 2. At
Yes.
that time, accused chased Santosh by holding an axe and thereafter attempted to inflict Budia blow to Kailash, to which Kailash caught hold of Budia, and in course of that Kailash sustained injury on his hand. Thereafter I left for my house. And paragraph 3 my lord. I again came to the spot when police came. I found the headless body of the deceased Basudev lying there. Police held inquest over the said headless body and prepared inquest report in my presence.
No, Basudev is the deceased.
My lord.
This man has seen the appellant chasing one Santosh. And then dealing one blow to Kailash. Okay. He has not stated about the assault on the, whether the deceased has any other name or what.
No, Basudev Mohanty.
Only.
My lord.
So let us come to the next witness, see that it is not. Acha, he has been declared hostile, PW 5. Come to PW 6.
6, my lord. She also hostile, my lord. He also hostile.
He has also not stated that I was present in the house after killing it while we were going to share. At that time, accused came chasing Santosh, the grandson of the deceased, holding one swan, shouting. On seeing us, he also disclosed not to spare. Saying so, accused attempted to inflict Budia blow on me, which I caught. There was a tussle. Myself and accused, I could be able to snatch away Swansea in course of such tussle. So he has also been declared hostile. Next witness is PW 7. PW 7 from Kochi. Acha, child witness. Informant is my uncle. Deceased is my grandfather. Being the father of my father, I know the accused standing in the dock. At the relevant time, I was in the bari side. On seeing me, accused chased me holding a bodia. Kailash and Kirtan and my grandfather were there and were about to share a cock after killing it. As I ran away, the accused attempted to inflict, which Kailash caught hold of, and there was a tussle, and in course of the said tussle, Kailash sustained injury. Kailash fled away. Thereafter, the accused assaulted my grandfather, for which he fell down, and thereafter the accused gave repeated blows and caused severance of the head from the body. So this witness has stated. So even though 5 and 6 have not stated, and practically no cross-examination to this witness. Just next witness is PW 8.
Informant. This is why.
He is a post-occurrence witness. On reaching at the spot, I found an headless body of the deceased was there. My elder mother disclosure light is a post-occurrence witness as it appears. So what about, let us see the doctor's evidence, PW 21. Assault Kutrela?
Assault man axe tankia jota axe.
I found arrow dekhi in kon upain deji, opinion deji. Please come to the evidence of PW 21.
21 madam.
Dr. Joy Krishna Tripathi to?
So 20 is the disease was identified.
Postmortem का अपन कहले परा PW 21 करथिला
20 करता है ना 20 PW 20.
Okay. PW 20 is the doctor who conducted PM.
I made PM over the dead body of the
हाँ, इतना ठीक है जब अपन 21 कहले
21.
Head of the body was severed from the his body, headless body. Okay. Cause of death due to hemorrhage due to separation of the head from the body. So now this two witness 7 and 20. If these two are believed, then so the period is you have remained in custody for
10 years 7 months.
10 years 7 months.
The custody certificate.
से पहले जो 3 आई विटनेस 5 6 8 are the land and counsel for the petitioner and counsel for the state. The land counsel for the petitioner produced the custody certificate from granted by the senior superintendent circle jail Baripada, which indicates that the petitioner is in judicial custody for more than 10 years. Certificate is taken on record. Land counsel submits that the occurrence in question took place on 16/10/2013 and prosecution examined PW4, PW6, PW7, and PW8 to be the eyewitnesses to the occurrence. But from the evidence of PW5, 6, and 8, no clinching evidence has come against the petitioner. And PW7 is a child witness and mainly relying on his evidence, also the evidence of the doctor, bracket PW20, who conducted post-mortem examination. The conviction has been um, conviction is based on relying on this evidence. Further submit that though the case is of the year 2016, appeal is of the year 2016, but no paper book has been prepared, and therefore there is no chance of early hearing of the appeal, and the petitioner may be granted bail. The learned counsel for the state opposed the prayer for bail, placed the evidence of PW7 was stated about the role played by the petitioner, and also placed the evidence of the doctor PW20 was stated to have conducted autopsy when the head of the dead body was severed from the body over the headless body, and opined that the cause of death was due to hemorrhage due to separation of the head from the body. Considering the submission made by the land counsel for the respective parties, nature of evidence adduced by the prosecution during trial, post-mortem report finding, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention in judicial custody and the observation of this court in the case of so and so, 3 months bail granted. Report to be obtained by the from the IAC of concerned police station about his conduct. He shall not indulge in any criminal activities, violation of any terms and conditions shall entail cancellation of bail, stay realization of fine. Yes.
Item number 25.
May please. May please. As the appearance since 2010, 2020.
There are 2 criminal appeals, and you are appearing, no, not 2. This is there are 5, 6, 5. You are appearing in which one?
First one.
First one.
331 and
Okay. Just a minute. You are at the 331 2017. Lokti alias Siddharth Rushdie. Yes, you have filed a bail application. Okay.
Minors.
So, what is the date of custody?
Minors 2010, 2011 minors.
2010-2011.
Minors.
You are not on bail during trial.
No, minors. I am during trial. I am in bail. Under 6/9, 2013.
So, during trial, you are on bail.
Yes, minors.
Then, when the conviction, the order was passed, judgment was passed.
17/3/2017, minors.
17/3/2017. And after the appeal was preferred, have you been
Yes,
enlarged on bail?
I'm religion bail. Had IN number 515.
Date order order dated
15/3/2023 minors.
15/3
2023 minors.
ଗୋଟେ ଥର
ଥରେ minors.
କେତେ ମାସ ପାଇଁ?
12 weeks.
12 weeks. ତ ଆପଣଙ୍କର detention period କେତେ ହେଲା?
Near about almost 9 years minors.
So, what is the name of the deceased?
Sunita Pushti minors.
Sunita Pushti.
Yes, minors.
What are the offenses under which you are found guilty?
Minors, that 302 and 120B.
My lord has granted bail to all other co-accused persons last occasion, my lord. It was
Okay.
listed. So he was on BC, could not appear through BC. That's why it was
Acha.
adjourned, my lord.
Who
My lord, 242, 250, 45, 252. Because as the co-accused is released on bail, my lord, main co-accused, that is CRLS 332.
Acha. Running counsel for the petition submitted a petition was on bail during trial. After conviction, he was released on option. Placing the deposition of the eyewitness, particularly PW6, who is the mother of the deceased, Sunita Prusti. It is argued that the main accusation is against accused Bikku alias Sunil Kumar,
That is CRLA
who
332.
stated to have fired gunshots at the deceased Sunita Prusti, which resulted in her death, and the said accused Bikku Swanso has already been released on. Oh, that is how the
Others
other. So same footing, no?
My lord.
The order ଯୋଉଟା ଅଛି ଆମର 245 ରେ ସେଇ order ଟାକୁ ଇଏ କରିଦେବେ ଆପଣ ହେଲା all right bail allowed
Item number 26.
we are just coming now just come.
Right. Item number 26.
Your Lordship.
single appellant
Yes, Your Lordship.
conviction under section
302 IPC, Your Lordship.
okay. So what is the name of the deceased?
This is the wife of the appellant, Ambika Tati.
Anita
Ambika Tati. Tati.
TAKI
TATI.
Tati. What is the date of marriage?
Date of marriage 9 years before the occurrence, Your Lordship.
Issue out of wedlock?
Two children, Your Lordship.
Cause of death?
Cause of death is 85% burn injury, Your Lordship.
When the occurrence took place?
10/7/2014 night.
When she died?
After 8 days, Your Lordship, 18/7/2014.
DD recorded, dying declaration.
Yes, Your Lordship. Treaty, recording Dr. PW 6, Exhibit 3, the dying declaration, Lordship.
Deposition copy not supply mail.
Exhibit 6.
Exhibit 3, Your Lordship.
We'll just Exhibit 3 type. Exhibit 3 ହେଲା ତୁମର ନାଁ ଅମ୍ବିକା ବିନାଟ। ତାଟି କଣ କହୁଛନ୍ତି ତା ନାଁ ଲେଖା ହେଇଛି ବିନାଟ ବୋଲି।
Husband title is Binat.
ତମର ସ୍ୱାମୀଙ୍କର ନାଁ ତ୍ରିଲୋଚନ ବିନାଟ। ଘର କୋଉଠି? ଗାଁର ନାଁ ହେଲା ବତୁଣ୍ଡା। କୋଉଠି ଅଛ? ନୂଆପଡା ହସ୍ପିଟାଲରେ। ହସ୍ପିଟାଲକୁ କାହିଁକି ଆସିଲ? ପୋଡିଗଲି। କେମିତି ପୋଡିଲ? ମୋର ସ୍ୱାମୀ କିରୋସିନ ଢାଳିଦେଲେ ଆଉ ମାଚିସ୍ ମାରିଦେଲେ। କେତେବେଳେ କଲେ? ରାତି 8ଟା ବାଜେ। କେଉଁ ଦିନ? ଗୁରୁବାର ଦିନ। ତାରିଖ ଜାଣିଛ କି? ଜାଣିନି। So this evidence of PW6 along with this dying declaration, Exhibit 3. So what is your submission?
Submission, Your Lordship. Some discrepancy is there in the dying declaration. No signature or LTI of the deceased is there, Your Lordship.
Is a case of burn injury. How are the maybe that the LTA might have been affected on account of burn injury, so it is not possible to take LTA. So other witnesses, what they have stated? The family members must have also stated that about your torture.
That part has not been proved, Your Lordship.
Or parents have not been examined.
Parents were examined. That part has not been proved. Therefore, no charge has been proved under Section 498A.
Okay.
Charge is there, but that has not been proved.
So only offense you are facing trial is 302.
302, 498A, Your Lordship.
You said that there is no 498A. You have been acquitted. Or?
Yes, Lordship.
That you said. So 498A acquitted. And there are also other offenses like 307, 326.
Initially 307, 3020 under 326 FIR has been registered.
No, charge you are also framed for face trial.
Because in higher offense, charge sheet has been filed. Therefore, only charge has been framed under Section 498A 302.
Mr. Counsel, please come to the first page of the judgment. See that the charge has been framed under 498A, 307, 326 and 302. Facing trial, the word has been used. So why do you say that no charge has been framed? Might have been acquitted is a different matter, but 498.
My lord, in paragraph 4, Your Lordship.
Paragraph 4.
It appears the court has framed charge under Section 307, 326. Perusal of the case
it appears that court has framed charge under the perusal of the alleged offense. Charge under section should not have been framed. Oh, should not have been because it merged with. That was it. All right. So pouring kerosene on your wife, setting her fire, and dying declaration recorded by Dr. PW6 as per Exhibit 3. in which she has stated that you are the person who poured kerosene on her and set her fire. And a cause of death was also on account of burn injuries. So that is there.
In custody since 9 years, 10 months.
9 years. 9 years, 10 months.
My lord. 21/7/2014.
21/7/2014 is the date in which you are taken into custody.
My lord.
Okay, the key at a final formation. 21/7/2024 ঠিক আছে তাহলে are the learned counsel for the petitioner and counsel for the state. The learned counsel for the petitioner submits that the petitioner is in judicial custody since 21/7/2014. And as such, he has undergone substantive sentence of 9 years and 9 months. 9 years, 9 months. The death took place 9 years after the marriage, and the deceased and the appellant and the deceased were blessed with 2 children. The occurrence in question took place on 10/7/2014 midnight, and the deceased sustained burn injury, and she was hospitalized. And on 18/7/2014, she succumbed to the burn injuries. The Land Council further submits that even though charge was framed under Section 498A of the Indian Penal Code, the London Trial Court has acquitted him of the charge. The case is based mainly on the dying declaration, which has been recorded by PW6, the doctor, and by Exhibit 3. Land Council further submits that the surrounding circumstances under which the crime stated to have taken place and period of custody of the petitioner in judicial detention in judicial custody, and since paper book has not been prepared, there is no chance of early hearing. Therefore, the bail application may be favorably considered. Land Council for the state oppose the prayer for bail, place the evidence of the doctor PW6 to also the dying declaration bracketary Exhibit 3. Considering the submission made by the Land Council for the respective parties, nature of evidence adduced, surrounding circumstances under which the offense alleged to have taken place, period of detention of the petitioner in judicial custody, and absence of any chance of early hearing, we are inclined to release the petitioner on bail, stay relation of time. Yes.
Item 27.
May I please, your lordship?
Yes, Mr. Naik.
My lord, the petitioner is in custody since 29/6/2014, so more than 9 years,
Just
about 10 years.
1 minute, Mr. Naik. Is it a case of single appellant or Jula?
Single appellant, madam.
Okay, Sukanto Das. And what is the conviction and what is the sentence imposed?
When other accused person, they are not. Conviction, my lord, under section 302/201 for IPC, my lord. And sentence array for life.
201 kahin ki?
201 in respect of other accused person, my lord. So far, this is 302.
No, please come to the judgment operative part. Where is 201? We do not find it.
201 case was registered, my lord, but conviction so for this appellant is concerned under section 302.
Right. So there is nothing on 201.
So for this
302 IPC. What is the name of the deceased?
name of the deceased, my lord, Dipu alias Deepak Das.
Dipu alias Deepak Das. What is the date of occurrence?
My lord, date of occurrence is, my lord, 26 2014. 20/6/2014.
Okay. Any eyewitness?
No, my lord.
A deposition copy not supply, my lord.
Wait, yes, sir. And what is the case based on circumstantial evidence?
My lord, your lordship may kindly see para 7 of this judgment. It is mentioned. Para 7 of the judgment.
Para 7.
Para 7 of the judgment, your lordship may kindly see.
Last seen on 20/6/2014. Okay. Accused and deceased picked up quarrel. How they are related to each other?
Friends, my lord. They said they are friends. He has borrowed money. They were in a drunken state. Thereafter, money was not
Accused
repaid.
was not found in the night of occurrence and so departed with the accused by his motorcycle. Okay, extrajudicial confession,
Yes,
date of occurrence in killing the deceased. Accused absconded immediately from the night of occurrence, was apprehended, so on. Dead body of the deceased was recovered after
These are the circumstances. No eyewitness. These are the circumstances.
So, Mrs. Sahu,
My lord.
you see, why are you not collecting in your pen drive all these? Why are you asking him the deposition copies? Now
May I pray, my lord? Your lordship has directed me to collect in by pen drive. My junior has collected and served the copy.
you see the when the order is very clear. In view of the submission, let the deposition copies of all the witnesses examined in the trial court be supplied to the London Council for the state through pen drive to be given by the state council. That order was passed on the last date, that is on 8/5/2024. So you have to just give a pen drive and within 1 minute you will get the entire deposition copy.
Even see non la ame bhi deଇ ଦେଇଛୁ collect କରିକି ତାଙ୍କୁ.
ତେଣୁ ଆ ଦେହରେ ଗୋଟେ କଣ ଅଛି ଯେ ଆପଣ କଣ ପାଇଁ କଲେକ୍ଟ କଲେନି?
As this case was adjourned for this purpose only, and only to know, only to ascertain whether there are eyewitnesses or circumstantial evidence. That is that finds place in
based on circumstantial evidence as it appears.
Yes,
in
my lord.
paragraph number 7, it is mentioned that there are no eyewitnesses.
Yes, my lordship directed to examine this only.
So you are in custody since when?
Well, I am in custody, my lord, since 29/6/2014. 29/6/2014.
You are not released on bail during trial.
No.
Okay, and during pendency of the appeal also you are not granted bail.
No.
Oh, right. Almost it is going to be
10 years.
9 years and 10 months have already passed.
Yes, ma'am. Yes, ma'am.
Hard Mr. Dharanidhar Naik, Land Senior Advocate, to virtual mode. Land Council submit that the petitioner is in judicial custody since 29/6/2014. And it's a case where there are no eyewitness which are enumerated. It is further submitted that these circumstances are not clinching and do not form a complete chain, and there are good chances of success in the appeal. Balance of convenience is in favor of the appellant. And since paper book has not been prepared as yet, there is no chance of early hearing, and therefore the bail application may be favorably considered. Land Council for the state oppose the prayer for bail. Considering the submission made by the Land Council for the respective parties, nature of evidence adduced during trial, period of detention, the petitioner in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed.
I'm obliged.
Item 28.
May Premala, this is my matter also day after tomorrow. I'm not ready day after tomorrow.
Okay, you'll call this matter from the okay, it will be taken up on 15/5/2024. Okay.
Item 29.
My lord, I am appearing on VC, my lord. Sorry, my lord. But today we have received the file, my lord. My lord, next week, my lord.
You want adjournment?
Next week, my lord.
Next week only 2 days are there, so it would not be possible. Let it come after ensuing summer vacation.
My lord.
You are Mr. What is your good name?
C.K. De, Chandan Kumar De. C.K. De.
C.K. De. Mr. C.K. De, Land Counsel appearing for the appellant, 6 for an adjournment through virtual mode. No? Put up this matter after ensuing summer vacation.
Item 30.
এটা এই যে IA এর অর্ডারটা পাস করিবে IA number so and so, this is an application for bail, then you are this matter. Yes, item number 30, Vijay Kumar Mahanti. डिस्प्ले था ये देखुछन तो डिस्प्ले बोर्ड रे आइटम 30 चलची बोली. ओके, नेक्स्ट.
Item 31.
May I please, Your Lordship? My lord, this is a case under section 302 and 34 IPC. My lord. The petitioner is in
How
jail.
many appellants are there?
4. One died at 4.
No, in this particular appeal.
Yes, my lord.
One appellant. Prashant Ghadi.
5 accused person, my lord, and 1 dead.
So, counsel, we are asking a question.
In this case, one appellant, my lord.
CRLA number
48, my lord. 1 appellant.
Now you see how many interim applications you have filed.
My lord, I want to place only 1049. By the rest of the petition be treated as withdrawn, my lord.
IA number 405 of 2023, the Learned Counsel for the appellant does not want to place this application. Then IA number 67 of 2021, it are not placed. IA number 450 of 2021, not placed. Now you are placing 1049 of 24. All right?
Yes, ma'am.
Just a minute. You are in custody since
6/7/2013.
6/7/2013.
Yes, ma'am.
You are not granted bail during
interim bail has been granted to me on 14/11/2022.
Your question since when you are in custody, you are telling that.
My lord, I am in custody from 6/7.
So you during trial you are on bail.
No, ma'am. I am in jail.
कौन कौन दिया?
Sir, during trial, bail has been not given to me.
अभी कौन कहले bail रे जाइथिले?
Bail, my lord, High Court has given interim bail, my lord.
Has trial court कथा होंदो. So during trial you are not on bail.
Yes, my lord.
And during the pendency of this appeal,
yes, my lord,
how many times you are granted interim bail?
Once, my lord.
On what date?
14/11/2022.
14/11/2022.
Yes, ma'am.
कितना मास पाई?
6 weeks, my lord.
6 weeks.
Yes, madam.
Then
I have surrendered and I will in jail.
ठीक है जी. आउ केबे जाइथिले?
आउ जाए.
दुई थर केमती हला?
थरे सर 14/11/2022
माने आपण एबे कहले दी थर मु जाईची इंटरिम बेल
once my lord
once
once 6
Alright.
weeks
So after completion of the interim bail you surrender at right time.
right time.
Okay. Now what is the name of the deceased?
Sudam Gade.
Date of occurrence?
5/7/2013 man.
You have been convicted under section 302.
302 and 34 IPC man.
Let us see that. Right. Life 5,302.34. What is the name of the deceased?
Sudam Ghade, my lord.
Sudam Gade.
Acha Sudam Gade gala. Date of occurrence?
5/7/13 man.
7/7/2013.
No, no, 5
5/7 man.
5/7. Eyewitnesses are there?
My lord.
My
Who are
lord,
they?
eyewitness, my lord, as per the police, PW 13. They at the time of 161 statement, they have not deposed anything.
ପରେ କହିବେ ତା ବିଷୟରେ ମୁଁ ଖାଲି ପଚାରୁଛି ଆଇ ୱିଟନେସ୍ ଅଛନ୍ତି କି ନାହିଁ?
Yes, madam.
Who are the eyewitnesses?
7, 8, 8, 9. 7, 8, and 9.
7, 8, and 9 are the eyewitnesses.
Yes, madam.
Let us come. And who is the doctor first? Tell me.
PW 12, madam.
Huh?
PW 12.
PW 12 is the doctor.
Doctor.
Okay, so come to one eyewitness. Let us see. PW 7. Read from paragraph number 2.
The occurrence took place on 5/7/2013 at about 3 p.m. On the date of occurrence, my father and my uncle Subhas Gadi went to our bus stand horizon side to inquire about missing objects from our old house. At that time, the present accused persons and accused Bapi Ghadi, being armed with sword, a kati and lathi, chased my father and my uncle and attacked them. My uncle escaped, but my father fell down. The accused person, Bapi Ghadi and Babu Ghadi, caught hold of my father. Accused persons, Prasant Ghadi, Pintu Ghadi, and Amar Ghadi assaulted to my father by means of sword and lathi. As a result, my father died at the spot. Thereafter, my uncle Subhas Gadi reported the matter to police.
So, two persons, as it appears,
Yes, ma'am.
caught hold of the deceased, and then 3 persons assaulted the deceased by means of sword and lathi. And you are one of those persons who assaulted the deceased. So that is the evidence also of the other eyewitnesses.
Yes.
8 ଆଉ 9
No. କିନ୍ତୁ ସାର୍ ପୋଲିସ କହିଛି 161 ଷ୍ଟେଟମେଣ୍ଟ ଯେତେବେଳେ ଦେଲେ 7 1 ରୁ 6 ହଷ୍ଟାଇଲ 7 8 9 ରେ ସେମାନେ ଦେଖି ନାହାନ୍ତି ବୋଲି କହିଛି ଦେଖିଛନ୍ତି ବୋଲି କହିନାହାନ୍ତି ଅଫେନ୍ସ
then you should have put the confronted the previous statement to this witness and proved through the have you
yes
put
yes
it?
paragraph 25 paragraph 25 of PW 13 the IO it has been put
ତାକୁ confront କରି ସେଠୁ ବାହାର କରିଛନ୍ତି let us see PW କେତେ
13 madam
13 is the IO ଅଛି
IO
କୋଉ paragraph ଟା କହୁଛନ୍ତି
25 madam
25 Acha, on perusal of 161 statement of
PW 7
that I do not find that they stated before me that they are Acha, are the still on council filed a petition to urgent for further so would approve each the paragraph 7 or 23 did not state okay so Mrs. Sahu
My lord.
ଆପଣଙ୍କର ଯୋଉ 3 ଜଣ ସାକ୍ଷୀ ଆଣିକି ଆଇ ୱିଟନେସ୍ ହିସାବରେ ଦେଲେ
My lord.
ସେମାନେ 161 ଷ୍ଟେଟମେଣ୍ଟରେ ଆଇ ୱିଟନେସ୍ ହିସାବରେ କିଛି କହିନାହାନ୍ତି
My lord.
First time asi court re evidence dele confront ହେଇକିନି prove ହେଲା.
Another eyewitness is there, my lord, PW11, my lord. Who is the informant in this case? PW11, my lord. Who is the informant, also informant in this case?
କହୁଛନ୍ତି 3 ଜଣ ଆଇ ୱିଟନେସ୍ ଅଛି. Let us see PW11.
Para 4, my lord, on the top para.
Please read it out then.
I saw accused person Prasanta Ghadai, the present petitioner, Papi Ghadai, Babu Ghadai.
Evidence ପଢୁଛନ୍ତି PW11 ତ?
PW11, my lord.
Para କୋଉ
Subhas Ghadai.
paragraph?
Para 4, my lord.
Para 4 start ହେଇଛି on that day.
On the top line 6, my lord. I saw accused.
अच्छा प्रशांत बापी हाँ.
My lord. I saw accused persons Prasanta Ghadai, Bapi Ghadai, Babu Ghadai, Amar Ghadai. Prasanta Ghadai, one of the petitioner, my lord, in this case, were dealing blows on my brothers by means of Kati and Badi. The upper head back of my brother received cut and chopes injury, and my brother Sudam died at the spot, my lord. And so also doctor report also corroborated with the PW11, my lord. Have a glance on the statement of the doctor, my lord. PW12.
Is there any such contradiction?
Yes, my lord.
Which
PW13
11 number ସାକ୍ଷୀର
11 number ସାକ୍ଷୀର ସାର୍ ଚପ୍ଡ ହେଇନି, ସେ ହେଡଟା ବାଇଫିକେସନ ହେଇନି, ଇ ଚପ୍ଡ ହେଇନି. ସେ doctor reports I am giving to her.
Let us come to that IOS evidence. Like you have proved the contradictions in the evidence of PW789.
Yes, my lord. FIR I am going to.
So far as PW11 is concerned, he is the informant in the case.
Yes, my lord.
And
my lord, ସିଏ କହୁଛନ୍ତି ଯେ FIR ରେ ମୁଁ ଲାଠି ଧରି ମୋର ଭାଇ ସୁଦାମ ଗୋଡେଇଲା. ମୁଁ ଆସି ଦେଖିଲା ବେଳେ ମୋ ଭାଇ ସୁଦାମ ମରି. ମୁଁ ଆସିଲି ଆଉ ଦେଖିଲି FIR ରେ ଲେଖିଛନ୍ତି ସେ. ମୁଁ ଆସି ଦେଖିଲା ବେଳେ
ସାଇର ସେଇମାନେ ଖଣ୍ଡା
ଲାଠି ଧରି ମୋର ଭାଇ ସୁଦାମ ଗୋଡାଇଲେ,
ଭାଇକୁ ଗୁଡାଇଲେ,
ସାଇରେ ହାଣିଲେ. ମୁଁ ଆସି ଦେଖିଲା ବେଳେ
ମୋର ଭାଇ ମରିଯାଇଛି. So you mean to say that the informant is also a post-occurrence witness?
Yes, ma'am.
And paragraph 29 of the IOS evidence PW13. Mrs. Sahu.
My lord.
ये जो 13 number ସାକ୍ଷୀର IO ର paragraph 29 को ଆସିଲେ.
My lord.
Informant ର contradiction prove ହେଇଛି. It is a fact that PW11
My lord.
did not state to me that his brother slipped in the mud and that accused persons combinedly assaulted him, and that when he turned around he saw the accused persons assaulting his brother by lathi. It is a fact that in the informant did not specifically state as to which accused assaulted which part of the deceased. It's a fact that did not specifically. So this is the position. And 12
ସାର୍ ଡକ୍ଟର କହିଛନ୍ତି ସାର୍ ସେ ଇଞ୍ଜୁରିଟା ଆଣ୍ଟିମୋର୍ଟମ କି ହୋମିସାଇଡ୍.
No, though the evidence of PW11 indicate that sharp cutting weapon was used, yes, but the doctor did not find any injury which could have been caused by sharp cutting weapon. Yes. That is your submission.
Yes, sir. No, sir.
Confusion.
By para 3 kindly be seen, well. Para 3 re se କହିଛନ୍ତି para 3 the injuries were antimatter and homicidal in nature will କହିଛନ୍ତି se.
There was no cut injury or incised wound on the person of the deceased. That you are not following. Yes,
Para 2 re my lord କହିଛନ୍ତି the deceased died due to instantaneously as a result of extensive Carniocerebral injury, my lord.
से जो
Multiple organ failure,
nature of injuries गुड़ा सब confusion अच्छी.
my lord.
That you come to paragraph cross examination, paragraph 3, last line, last sentence.
My lord.
There was no caught injury, incised wound on the person of the deceased. Why this question was put to the doctor? Because your PW11, who is the informant in this case, has stated that during course of assault, the kati was used for dealing blows on the deceased. Kati is obviously a sharp cutting weapon.
My lord.
So no injury, caught injury or incised wound was seen. That is how this your three witnesses have stated for the first time. Informant in the FIR stated that he reached at the spot afterwards, and in the court, whatever she has stated, that is not getting support from the medical evidence adduced by PW12. That is a submission. Are the learned counsel for the petitioner, learned counsel, learned counsel for the state. Learned counsel for the petitioner submitted that the petitioner was taken into judicial custody on 6/7/2013, and during trial he was not granted bail, and during pendency of this appeal he was granted bail as per order dated 14/11/2022. এটিকে দেখে নেবে 14/11 order 14/11/2022 for a period of 6 weeks, and after availing the same, he surrendered at right time. The Learned Counsel further submits that occurrence in question took place on 5/7/2013, and though the prosecution examined PW7, 8, and 9 to be the eyewitnesses to the occurrence, but it has been confronted to those witnesses and proved to the IO that during investigation they have not stated before the IO as the eyewitnesses to the occurrence. The Learned Counsel further submitted that PW11, the informant, stated that during course of assault on the deceased, sharp cutting weapon like kati was used and repeated blows were given. But the doctor, bracket PW12, who conducted post-mortem examination, has stated that there was no caught injury or incised wound on the person of the deceased. And moreover, PW11, as per in the FIR, stated that he reached at the spot afterwards. Learned Counsel submit that in view of the evidence adduced by the prosecution during trial, there are good chances of success in the appeal, and balance of convenience is in his favor, and there is no chance of early hearing of the appeal, and therefore the bail application may be favorably considered. Learned Counsel for the state oppose the prayer for bail, considering the submission made by the Learned Counsel for the respective parties, nature of evidence adduced during trial, period of detention of the petitioner in judicial custody, and conduct of the petitioner in surrendering timely after availing the interim bail granted by this court. We are inclined to release the petitioner on bail and stay realization of fine. Granted, stay fine. Okay. Yes, what is the next one? Mr. Mahapatra.
Sir?
The next appeal, criminal appeal 36 of 20.
Later on, I will take.
Okay. CRLA number 36 of 2021, Mr. Mahapatra 6 for an adjournment. Adjourn. Yeah.
Item 32.
Yes, item number. You are appearing in which one?
Criminal appeal number 111 of 2021.
Item 32, CR 11, 111, 2021. Sole appellant.
In this case, 6
नहीं जो criminal appeal टा अपन फाइल
five
कर
appellants है.
तादेरे appellant संख्या कितने?
Total
CRL टा बाहर कौन जे CRL?
total 6.
Just a minute. Let us see the appeal memo. 1, 2, 3, 4, 5. 5 appellants are there.
Madam.
So you have filed the bail application for all the appellants or
All the 5
for all
appellants.
And what is the date of custody?
Date of custody 30/10/2015.
You were never released on bail during trial.
My lord.
And after conviction also you have not been granted interim.
My lord.
So it comes to about 8 years and maybe 6 months. Okay, it's a conviction under section?
My lord, convicted under section 147, 148, 341, 302, 149
So
IPC.
302 is there.
302 is there.
Okay. What is the name of the deceased?
Arjuna Bhue.
Arjuna Bhoi.
Bhue, BHUE.
Oh, BHUE.
Fine.
Date of occurrence?
Date of occurrence, Your Lordship, 27/10/2015.
Eyewitnesses are there?
Yes, Your Lordship.
Who are the eyewitnesses?
PW2, Your Lordship.
Only one eyewitness.
My lord.
PW2.
Yes, Your Lordship.
And who is the doctor who conducted PM?
My lord, PW10.
So let us come to PW2 first.
My lord.
Please place the relevant part.
I know the informant Jyotiraj Bhue and the deceased Arjuna Bhue. In this case, I also know all the 6 accused persons in this case. Your Lordship, out of 6 accused persons, 1 accused person filed separate jail criminal appeal. That is also before Your Lordship, 97 of 2000.
It's all right. You
Yes.
have filed for all the appellants in this CRLA, you have filed the bail application.
My lord.
Place the evidence of the eyewitness.
The occurrence took place about 1 year, 3.5 months back at about 8:30 in the night in front Narayana temple on the village street on the full moon day on Tuesday. On that day, I was returning from Vijaypur along with the deceased to our house. No sooner did we reach the spot situated in front of Narayan temple, accused Sarath Barge attacked the deceased with a wooden baton. I intervened, and at that time, accused
Sarath Barge is appellant number?
Sarath Barge. Appellant number 2, Your Lordship.
Attacked the deceased with wooden
baton.
I
intervened, and at that time, accused Hare Krishna appeared there armed with another wooden baton and assaulted me. But I managed to catch hold of that baton. At that time, other co-accused persons, namely Chandrasekhar Barge, Pramod Barge, Rasa Barge, Kesava Barge, and Sarath Barge gathered the deceased and started attacking him. The deceased sustained bleeding injury on his head and fell down senseless. Subsequently, with the arrival of the villagers, the accused persons ran away from the spot.
So the name of all the appellants find place here who have assaulted the deceased after gherawing him.
My lord.
right?
My lord.
So anything you have brought out in the cross examination, or will go to the doctor's evidence? Who is the doctor conducted PW10? Let us come to that PW10.
My lord. ହାତରେ ଲେଖା ହେଇଛି। My lord, on 9/11/2015, I was working as assistant professor in the FMT department, SCB Medical College Hospital, Cuttack. On that day, I conducted postmortem examination over the dead body of one Arjuna Bhoy, son of Usha Bhoy of Mauja Pahal, PS Soila, on receipt.
When the death took place?
Death took place, Your Lordship, on 9/11/2015.
କାରଣ ଆଦେର ଅଛି ନା partially healed stitched wound ବୋଲି ଅଛି. So 9/11/2015 ରେ death ହେଲା.
My lord, after 13 days. And found presence of.
She was all through in the hospital, or after recovery she went and again taken to the hospital?
Initially, he was taken to Soila Hospital. From Soila, he was taken to Bulla Medical, and from Bulla Medical, while he was treating at SCB Cuttack, he died. Your Lordship.
So, as it appears, the I found the whole of this one. So. Fracture from the right. All the injuries are paragraph number 7. All the injuries are antemortem in nature and caused by hard and blunt trauma with about 1 to 2 weeks prior to the death. So lathi has been used by all of them.
3 lathi has been seized.
Are the learned counsel for the petition, learned counsel for the state?
Pardon to mention, my lord.
Yes.
In this case, my lord, no. Counsel was submitted that one eyewitness, but no, my lord. In this case, 1, 2, 3, 4, 5, and 7, 8. All are the eyewitness in this case, my lord.
So, counsel, what do you say?
1, 2, 3, 1,
1, 2, 3,
1,
4, 5, and
3,
7, 8
my lord,
also.
1, 3, 4.
କେତେଟା eyewitness ଆପଣ କହିଲେ PW2?
My lord, 1, 3, 4, 5,
ସେଗୁଡ଼ା ସେତେବେଳେ କହିଲେନି?
7 reach after hearing the hulla from the spot, Your Lordship. And
Koudi, keep
PW2 was with the deceased, Your Lordship.
ସେ କହିଛନ୍ତି ଆମେ ପରେ
My lord, yes, Lordship.
Let us switch.
On the day at the
No, no,
relevant
no.
time, I was in my house and hearing hulla, I came to and saw all the
କାହା evidence place
PW1.
କୋଉ line ଟା?
My lord, paragraph 3 starting.
Paragraph 3, my lord.
3.
Paragraph 3.
On that date, at the relevant time, I was in my house and hearing hulla, I came out and saw all the accused persons to have surrounded the deceased. I also found all the accused person attacking the deceased. All are the corroborated to each
From
other.
he got it that he came to the spot hearing hulla and saw the assault.
My lord.
So how he will be a post occurrence witness?
My lord, 1, 3, 4, and 5 are saying so, Your Lordship.
Why are you making such submission in the
My
High
lord,
Court?
I have not strong submission, Your Lordship. PW2 was with the deceased, Your Lordship.
That's all right. But when we asked you that how many witnesses, eyewitnesses are there, whether that witness is to be believed or rejected on the basis of appreciation of evidence, that's a different matter. But you are supposed to say that these are the eyewitnesses, but the evidence of these witnesses cannot be believed because the evidence on record indicate that they come afterwards.
Sorry, Your Lordship.
Okay.
1, 3,
That should be the. So who are the Mrs. Sahu? PW
1, 3,
1,
4,
2,
5.
3, 4, 5, 7, and 8.
7, 8,
4,
hostile.
5, 7, and 8.
7, 8 not supporting the prosecution case. 7 is the informant.
Okay.
He lodged the affair after hearing about the occurrence from PW 1, 2, 3, 4, and 5.
8 has not supported.
My lord.
7 has supported.
7 the informant.
8 also supported. 8 also supported, my lord. At that time, I was returning home after attending call of nature from the pond side of our village and hearing hula. I came to the spot and found all the accused persons who have gathered.
There should not be any incorrect statement from you. So we don't want this, sir.
My lord. Sorry, Your Lordship. I have read.
Please come to PW8.
My lord. My lord. The occurrence took place about 1.5 years back in the night of full noon day of the Sahara. That is on 27/10/2015 at about 8 p.m. to 8:30 p.m. in our village road running in front of our village temple. At that time, I was returning home after attending call of nature from the pond site of our village and hearing hulla. I came to the spot and found all the accused persons. There, Your Lordship. Accused persons to have.
What does it mean? I came to the spot, found all the accused persons to have gear out the deceased and were assaulting him with wooden batons, and the informant was persuading them not to assault. What does this line indicate?
My lord, that is.
This is very unfortunate.
Sorry, Your Lordship. Sorry, Your Lordship.
Are the learned counsel for the appellants, petitioners, learned counsel for the state submitted that the petitioners are in judicial custody since 30/10/2015, and as such they have remained in custody for 8 years and 6 months. The occurrence in question took place on 27/10/2015. And as per the prosecution case, PWs 1, 2, 3, 4, 5, 7, and 8 are the eyewitnesses to the occurrence. And they have stated that the appellants assaulted to the deceased Arjuna Bhue, BHUE, by means of wooden baton. It is further submitted that the deceased was shifted from hospital to hospital and ultimately he was treated at SCV Medical College, Cuttack, where he died on 9/11/2015. The learned counsel submits that there are good chances of success in the appeal and balance of convenience is in his favor. And there is no chance of early hearing, and therefore the bail application may be
Pardon, Your Lordship.
favorably considered.
One of the land was granted bail by Your Lordship, by this honorable court.
Who?
My Lord.
Out of these
6, Your Lordship. In JCRLA, Your Lordship. Appellant Hare Krishna Barge.
His appellant number?
My Lord, he filed separate appeal, Your Lordship.
अरे सी आपण appellant number केते एई जो सी तो फाइल कला
ମୁଁ 5 ଜଣଙ୍କ ପାଇଁ କରିଛି, ସେ ଅଲଗା କରିଛି।
Acha, he is not the one of the appellant in your case.
No.
He further submits that the who accused who accused Hare Krishna Barge, who also faced trial along with the appellants and convicted for the self-same offense, has been granted and preferred JCRL number 97 of 2022 has been directed to be released on bail as per order dated 25/9/2023 in IA number 106 of 2023. And since the petitioner stand on the similar footing, the bail application may be favorably considered. Are you sure that you are not on bail during trial?
Yes, Your Lordship.
The learned counsel for the state opposed the prayer for bail, placed the evidence of the eyewitnesses. However, doesn't dispute that the petitioners are similarly situated, like the co-accused Hare Krishna Barje, who has been granted bail in the connected JCRL. Considering the submission made by the learning counsel for the respective parties, nature of evidence adduced, period of detention of the petitioners in judicial custody, the release of the co-accused on bail, absence of any chance of early hearing, we are inclined to release the petitioners on bail allowed.
Item 33.
Yeah, please, Your Lordship. The present appellant was convicted for life under section 302 IPC manner. And he is inside custody, my lord, since 14/4/2016.
Just a minute. CRLA 412/2023. Single appellant?
Same.
Single. Husband.
Huh?
He's the husband.
Jaya Duria. So, what are the offense under which you are found guilty?
The charge has been framed under section 498/302, but the present appellant convicted under section 302 IPC.
498 acquitted.
My lord.
302 IPC. You are the husband.
My lord.
Let him serve the deposition of your life.
No, you take the pen drive. We'll see that. Husband, what is the name of the deceased?
She, my lord, Champa Pedal.
Champa?
Champa Pedal. P-A-D-E-L.
Huh?
Champa Pedal.
K-A-D-A-L.
My lord.
What is the cause of death?
Cause of death as per the doctor's evidence, my lord, PW12. Death occurred due to manual strangulation causing thyroid cartilage and cricoid cartilage fractured, leading to vagal inhabit.
And what is the date of custody?
14/4/2016.
14/4/2016.
The case is based on circumstantial evidence, my lord.
And
PW 6 to 10, they are the independent witnesses, not supported the
ସେମାନେ କଣ କରିବେ ଆପଣ ଘର ଭିତରେ କାରବାର ହେଇଛି ଆଉ ସେଟା ସିଏ ବାହାର ଲୋକ କଣ କହିବେ manual strangulation ପୁରା
PW9 is the son of the deceased man. PW9 is the son of the deceased.
କଣ କହିଲେ
And she not supported the prosecution case and stated due to fits. Earlier, she was suffering from fit, my lord, the deceased, my lord. In which
the dead body was lying in your house where you, your wife, and that child, PW9, were staying.
The petitioner was staying outside of the state, my lord, at Andhra Pradesh. After listening the fact, the petitioner came to the spot and taken.
Who has stated that?
The son of the deceased, my lord.
PW9.
My lord. My deceased mother was staying with us and we are taking care of her. At that time, my father was staying at Andhra Pradesh with my stepmother. There was no quarrel between my deceased mother and acute father. At point of time, I received phone from my brother that my mother died due to fit. As she fell down.
Your defense plea is that you are not present in the house, at the time of occurrence. That is your statement. How the London trial court has dealt with it? How the London trial court has dealt with this, that your absence, se bishare kichi judgment re discussion heichi?
सस्पेक्ट करछन जे ये मारिछि बोली जो इन्फॉर्मेंट स्टेटेड informant not eyewitness to the occurrence after hearing the fact came to the spot and found she is laying dead.
Shall I
And
pray, my lord? I will collect it today. Let it taken up on Wednesday, my lord.
All right, you see,
I will collect it today.
all the
My
no,
lord.
now it will not be supplied to you. Just
My
collect.
lord, I will collect it
All right, it will be taken off on
Wednesday.
8/5 2024. We'll take up the rest of the matter after lunch.
Oblate.
Item number 34.
Madam, may I submit on behalf of Mr. Jaina and power that well, the appellant is in custody since 25/8/2014 in relation to the offense. My lords. Here is the sole appellant, Your Lordship. The other convicts have filed the separate appeals wherein they have been granted.
You are the sole appellant. And what is the conviction and sentencing for?
Well, the
Life
conviction
infringement, my lord. Life infringement is there.
302.
302.
302 year.
302, 149 achi. 147,
What is the date of first producer?
25/8/2014.
That is in the judgment first page. Your lordship.
In the judgment first page, Your Lordship. It has been.
Sorry, second.
You are not released from.
My lord, I am not.
So, what is the name of the deceased?
This is your Ravindra Malik.
Date of occurrence?
Date of occurrence is
24/8/2012.
24/8/2012 at about 7:30 a.m.
Eyewitnesses are there.
My eyewitnesses are there, Your Lordship. One eyewitness, Musa Malik, PW number 23. Thereafter, he disclosed the incident to others. Right.
Doctor is
Doctor is PW 21.
PM doctor.
My lord.
PW 21.
PW 15 is the wife and informant as well as oral declaration is there.
So the dying declaration is also there.
My lord.
Before whom?
Before the wife informant, my lord. PW 15.
Before PW 50.
So let us go to that eyewitness.
My lord. PW 23.
Your earlier application not rejected earlier.
This is the first time.
Okay.
And other accused persons have been released on bail by Your Lordship while sitting with Dr. Justice S. Muralidhar.
No.
In criminal appeal number
CRLA number
186/2015.
2015.
My lord.
By which order?
They have been granted bail. This case number 336/2018, 5/5/2023 order. Well, this is what the order is.
5/5/2023.
2023. Four accused persons have been. My lord, this is a copy.
No,
One.
but in the judgment,
My lord.
it appears that you are the only person who was facing trial.
Well, it is actually, I was absconded here also. My lord. I was apprehended in the 2014. 2012 is the date of incident.
Okay, those persons, person, let us see that.
My lord.
Krishna Malik, Papi Malik, Kartiko, and Jotadhari.
My lord.
Bapi Malik is here, your lords. Bapi
Bappi
Malik
na.
is in this case. That is Papi Malik.
Papi.
No, as it appears that on the ground of this detention period,
My
they
lord.
have been granted.
My lord. Detention period, and there is
So
unlikely.
if we consider the evidence of PW 23 and this apparent and these apparents who have been released on bail.
So for the appellant number 4 in that case, my lord, CRLA 186 of 2015, he was holding a farsa, which was also recovered and query report was also given. But so far the present petitioner is concerned, he was holding a sword and injuries are there. Only
But
considering
that has not been
aspect,
recovered in
lordship,
UO 27.
considering that aspect inside the custody for 10 years, which my lord has observed in this order. In this case, he is already 9 years, 6 months. 9 years.
24, 25, 8.
9 years, 9 months ago.
Right.
9 months.
Let us see that
PW 23, your lordship.
Our role ta kono?
He was holding.
1, 2,
I
3,
believe that he
4.
was holding the Honda.
Fourth line I am reading, your
Fourth
lordship.
line.
I was sitting behind at Katia Bridge, and Jyoti detained us. Thereafter, the present accused and others came out from bridge side, being armed with weapon and joined with other. Kartika at first gave the Thenga assault to the deceased Rabindra, for which he fell down near field. Bapi, present accused, was holding Khanda. Then he, along with others, have showed assault to Rabindra Patti. Jyoti were holding Fatsa. That Jyoti, the appellant number 4 in the other case, he was holding that
No,
Fatsa.
but what is this line? Means he along with others. That means Bapi along with others have sword. Gave sword assault to the Rabindra. That means this Krishna Malik and Papi Malik. They stand on the similar footing.
Same on the similar footing. That
similar footing. Are the land council for the upland land petition and land council for the case. The land council for the petition and submission. The petitioner is in pursuit since 25/3/2014. And occurrence in question took place on 24/8/2012. And the eyewitness to the occurrence, this PW 23, has indicated the petitioner, also the two accused persons, Botto alias Botto Krishna Malik, Papi Malik, Kartik Malik, and Jyoti alias Jottadhari Malik, in the assault of the deceased Rabindra Malik by different weapons. And the other 4 accused persons who have preferred criminal appeal number 186 of 2015 faced a separate trial in connection with the same offense, and they have been enlarged on bail as per the order dated 5/5/2023 in this case number 336 of 2018, mainly taking into account the detention period. And he files the copy of the bail order which is taken on record. Then counsel further submits that since the petitioner is similarly situated like the accused persons who have been convicted and released on bail, connected criminal in the connected criminal appeal number so on. And there is no chance of early hearing of the appeal. The bail application may be favorably considered. Current counsel for the state has not disputed that the petitioner is similarly situated like the other two accused persons as for the evidence of eyewitness PW 20 feet. Also the time declaration which was made before the widow of the deceased, that is PW 15. Considering the submission made by the land counsel for the respective parties, the nature of evidence adduced, the figure of detention of the petitioner is self-posted, absence of chance of the hearing of the appeal, here clear, release of the similarly situated parties persons on bail. We are inclined to release the petitioner. Is allowed.
Item 35.
Please, my lord. My lord, here the petitioner is languishing in jail custody since, my lord, 20th 10 2016. Under
I beg your pardon, my lord. In this case, I have already given the
Second of day after two.
Wednesday, your lord.
He has not received the deposition copy.
Day after two.
Pen drive.
Oh, like-
So day after two. On the 15, 5, 2020. Yes.
Item 36.
36 also, my lord, I have given.
No, where is the council? Singh is not there.
He was present first.
Present. All right, then we are 15-5 just intimate it or
My
Item 37.
May I please, your lord? My lord, I am playing for bail for appellant number 2, my lord. There are 3 number of appellants here. And I am
SIA which you have filed 887 of 24. It is for appellant number 2 only.
only, my lord. 1 and 2 have granted interim bail on 27 to 2024, my lord.
At that time, the bail application of this
No.
appellant was not filed.
No, my lord. This is the first time. No.
Appellant number 2 means Rama Rathadas.
Ramu Rathadas. Nice, my lord.
And what is the period of detention?
Period of detention, my lord, 2/5/2017, my lord. 7 years completed, my lord. 17, my lord.
And you have been found guilty under section
302 and 34 of the Indian Penal Code.
34 and
life imprisonment.
Yes, my lord.
Now, those persons who have been granted interim bail, as you said,
One appellant number 1, Dilip Das and Sudhira Das. They have granted interim bail on 27th February 2024, my lord.
24, 7.
27 to 2024. This is the order, my lord. 1 and 2 have granted. 1 and 3, my lord, sorry. 1 and 3 have granted interim.
Their bail application was rejected on merit, and they were granted in view of the evidence of the wife of the deceased, PW4, is an eyewitness to the occurrence. So
PW4.
trying to repeat bail. Okay. So anything that wife PW4 has also implicated you?
Yes, my lord.
He is the person who stayed.
Then cannot be based on merit. Question is whether you are to be granted interim bail or not. So your period and their period is same.
Same, my lord.
Are the running counsel for the petitioner and counsel for this? Then petition for bail filed by appellant number
Ramo Rathadas.
And counsel submits that the petitioner is in judicial custody since 2/5/2017, and two of the accused persons, namely Billy Das and Sudhira Das, who also faced trial along with the petitioner in the trial court, convicted under section 30 the IPC and other offences and sentenced to life imprisonment have already been granted interim bail for a period of
12 weeks.
12 weeks. As for order dated 27/2/2024, IN number 258 of 2023. Therefore, the bail application may be favorably considered. Then counsel for the state of the there for bail of the evidence of the widow of the deceased, PW.
Other two eyewitnesses are there, PW 6 and 9.
So also the eyewitnesses, PW
6 and 9.
PW 6 and 9. Further submit that the petitioner did the fatal blow.
My lord. He has only gave the blow. The two catch hold the hand.
Petitioner did the blow by means of a
Knife.
Knife.
Which part of the
Chest and
Middle of the chest.
chest.
Chest. And also clear the evidence of the doctor.
PW 15.
PW 15.
Considering the submission made by the Lion Council for the respective party in terms of the eyewitnesses, the postmortem report finding, while not inclining petition or on bail on the subject with the accused persons on bail and the detention inclined to the petition and telling the clear 12 weeks from the actual release from such strong consumption.
Item 38.
Yes, Mr. Nayak.
Appeal against a conviction, my lord. The appellant is in custody since 1/7/2022.
Under section
302, my lord, for life.
24.
Like
My lord, like.
Sole appellant.
Yes, my lord.
Custody date
Custody 1/7/2012, my lord.
7/2012.
Yes, my lord. 11 years, 10 months, 13 days, my lord. This is the Rajesh Das, my lord.
Date of occurrence.
Date of occurrence 29/6/2012, my lord.
Eyewitnesses are there.
Eyewitnesses PW number 5, 6, 8 and 16, my lord. But
PW 5,
6, 8 and 16.
6, then PW
8.
8
and
16. PW 8 and 16 have not cross examined, my lord. In spite of several notice, but PW 8, my lord, has not come to the court. He is the informant, my lord.
No, whether you decline both the witnesses and subsequently file 311 CRPC petition or what?
Can you see page 19, my lord?
Wait. PW date for date for that. PW 16 भी से है.
It is 16 advocate not examined.
PW 16 cross examination है. Further ये पे
Decline. Advocate for the accused so present in the court and go cross examination.
PW 16 पर.
Yes, my lord.
16 ଟା ହଉଛି କଣ ଶ୍ରୀମତୀ ନ
Purnavasi Das.
Cross-examination declined though present in court. The cross-examination PW acting still refused to cross-examine. He found that he had no instruction plan. He standing for response. এটা তো ডিক্লাইন হয়ে গেল আরেকটা কথা অলগা বাট এটা আপন ডিক্লাইন করে তারপরে আপন কি লেভেল পিটিশন ফাইল করিবে করছিলে এরকম যেটা দেখতে তো আচ্ছা ये बीटा को छाड़ो बाकी जो 5 6 कौन
Yes.
you have
High.
duplicated you or not
I thought injured I.
ये 5 please read that relevant line.
My son disclosed the incident to me. Rajesh came to know about it. Then he went outside to confront the accused. There was exchange of word between them. I made attempt to separate both of them, but the accused dealt blow by Kati on his chest. He fell down. While I made attempt to restrain him, he dealt a blow to me. Then I sustained injury on my left hand. He died on the spot.
Kati blow on chest.
Right.
With the doctor?
15. 15.
Yes.
I will give you the of penetrating star wound on the case of the victim is treated so on and so forth. So corresponding injury is there. And
Weapon also produced, where the report is there.
seven years, 10 months ago.
Previous one.
Are the learning counsel for the petitioner, learning counsel for the state. The learning counsel for the petitioner submitted that the petitioner will be since 1/7/2012. There are 4 eyewitnesses to the occurrence, that is PW5, PW6, PW8, and PW16. But so far as PW8 and PW16 are concerned, the petitioner did not get any opportunity to cross-examine, and they did not turn off for cross-examination. The land counsel further submits that it's a case of single blow on the chest of the deceased, and the petitioner has remained in custody for more than 11 years and 10 months, and it's a press criminal appeal. There is no chance of early hearing. Bail application may be favorably considered. Land counsel for the state oppose the prayer for bail, place the evidence of PW5 and 6, those to the doctor PW3. Considering the submission made by the land counsel for the respective party, nature of the dispute, did not incline petitioner on bail on the but taking to account the potential and absence of any chance of hearing. We are trying to and keeping the ratio let down in case of fraud. We are inclined to release the petitioner on interim bail the period of 3 months. Practice on the yes.
Item 39.
39, Mr. Pushpamitra Mahapatra, Ramesh Chandra Maharaj.
39 and 40, I pray for this.
He is appearing with the Ketana Movement. 40.
49.
This is not 39.
This is item 40. 40 delay is there.
No.
My pleasure, Lordship.
Please wait. 39, what do you want?
Day after tomorrow.
Day after.
Deposition document.
Pen type and equivalent.
नहीं है।
अच्छा, ठीक है. So it will come from the 15/5/2020. Yes.
My pleasure, Lordship. My Lord, judgment deliver 4/1/2023 आए 850/24 delay condemnation may be allowed.
What is the delay?
My Lord, 14 months. My Lord, if you are about to law, due to the personal illness, maybe could not file appeal by due time.
Life in prison.
We are concluding the deal. I a number so and so. Or Mr. Ashutosh party. Virtual ID. And Mr. Tripathi, London Action Standing Council. This term people responded out, sponsor with the delay. Planning Council for the respective parties. Since petitioner is right. And from whom in filing CRA is on R.K. Giving of application for bail and state detention of time will be considered after the receipt of the
Obliged.
That item 30 is passability. Put a 30 passable. बुधवार
item number कितने पहले
30.
PGR में नोट कर दो क्यों 15 तारीख में नोट कर दो hearing So we'll pick up item number 1.
Two ଯୋଉଟା ଥିଲା case ରେ ସେଟା
ହଁ ଆସିଲେ କି report?
ଆସିଛି ତମ affidavit କଣ ଫାଇଲ କରିଛ? They have to file an affidavit.
Just that's order dated is
2 तारीख ର order ଅଛି।
so it is 2 things. He has to file affidavit, his reliance. Number 2, from your side, the senior superintendent Circle Jail Pattanaik, he shall collect detailed information with reports on the past life, psychological condition, post-conviction, conduct of the appellants, and any such other matters which are relevant at the final hearing by taking legal assistance on. So, what report you have brought? Mr. Jafrullah, have you filed any affidavit?
No, not affidavit ready, I will file.
Huh?
Affidavit is ready.
Aji file kariye.
File.
Give the copy. What about you?
Mr. Tipwadi is there. Colleague from Tipwadi is there, yes. But he is. I'm already certain this. Tipwadi come. You want tomorrow?
Tomorrow.
Mr. Jafrullah.
Well,
So we'll take up this matter tomorrow. Since it is not ready.
minute. That in fact, I have
The report.
report has come.
And your affidavit is not ready.
In fact, I have prepared the affidavit.
We'll take up tomorrow just to see this report.
Not much.
Malat, I will amend something that tomorrow I will file. Tomorrow I will file in court.
Yeah. He will be put on the bit as per the order second name as per the order dated 2/5/2024. The Learned Additional Government Advocate Mr. Tripathi produced the reports relating to so and so from the age of Superintendent Kojal, which is taken on the Mr. Jaffrullah and counsel for the appellant submit that will file the affidavit tomorrow, giving copies to the learning action government. Yes. The hearing is will be taken up tomorrow. Yes. Item number 1. Continue for the issue. पेपर बुक टा दियो CRC of criminal